And a very good evening and welcome to Politics 101 on a Friday evening. Welcome to all of you where you're joining us from, whether you're joining us from Guyana or you're joining us from outside of Guyana or Caribbean or wider Caribbean, to all of you joining us from North America, those of you in the United States of America, in Canada, welcome to Politics 101. Welcome to those of you who are joining us from Europe, especially those of you in England and France. I know quite a few of you joining us from those countries. Good night. Good night to you. Hello to those of you who are coming to us from Paramaribo in Suriname, in French Guyana. Welcome. Welcome to Politics 101. Tonight we're going to be talking about the law. We're going to be talking about the law tonight. So saddle up. And our guests tonight are attorneys at law, Roysdale Ford and Nigel Hughes, and Brother Eusi Kwayana. I told you all I wasn't going to tell you all who our surprise guest is going to be on tonight. Brother Eusi Kwayana is here, along with Roysdale Ford and Nigel Hughes. So please get ready. Good evening. I know this week has been quite a week. We have had some programs that many of you have called about, and I'm trying to rebroadcast some of them. We're going to do so on the weekend, but tonight promises to be another interesting program. Those of you who were following the emancipation activities, and you know we had quite a few of them, but there were two forums in particular, one at Buxton, the Eusi Kwayana Emancipation Symposium, it's an annual symposium, and then Coffee 250 at the State of the African Guyanese Forum a few days later. Well, at the Buxton Forum, one of the presenters, as you remember it, was Roysdale Ford, and Roysdale dropped a bombshell, and that he said there was an article in the Constitution that compels the government to intervene if a group feels that it is not being treated fairly. And almost all of us in the room were surprised at that part of the Constitution. And then a couple of days later, Nigel Hughes, appearing at the Coffee 250 Forum, also cited that section of the Constitution. And again, people were surprised. Article 15 in the Constitution. Now, we had gotten accustomed to Article 13. There's actually a group by that name, Article 13. But Article 15, we were not au fait with that article in the Constitution. I'm going to have the lawyers read it for you just now, once we get started. But I spoke to Brother Eusi Kwayana sometime after those presentations, and he indicated to me that he knew something about Article 15 and that he had mentioned it in a public forum that he participated in some 2 or 3 years ago. It was a Ipadaji forum, and that he had mentioned it. And in any case, he chided me because he had mentioned it to me, and I had completely forgotten. Long and short of the story is that this part of the Constitution was put in there during the constitutional reform process a couple of decades ago. And this particular article was part of a WPA proposal to the commission, and that Kwayana, of course, who was then very active in the party, had something to do with initiating and drafting and so on with the proposal that went to the election, the Constitutional Reform Commission. So I thought we would do a show on it. I will have both Roysdale and Nigel, and of course we'll have Brother Eusi, and he agreed to come on. So Brother Eusi is going to join us via phone, and we have, of course, Roysdale and Nigel who are joining us here. So welcome again to those of you who are joining us. I notice you all are gathering. Welcome. Welcome to Politics 101. Let me bring in our guests. Let me bring in first Roysdale. Good evening, Roysdale.
Hi, good evening, Dr. Hughes. Thank you for having me again on your show. And good evening to the audience.
Thank you. And Nigel, good evening.
Hey, Doc. Good night. Good night to you. Good night, Roysdale. Good night to your audience.
Good night,
gentlemen. You heard my introduction, and of course, we have Brother Eusi here. Let me see. Brother Eusi, good evening.
Hello, good night.
Good night.
Brother David.
And
everyone.
Good night, brother.
Good night, Senior.
All right. Roysdale, let me start with you. I think we've lost both Roysdale. I don't understand why. Here we go. All right. Roysdale, let me start with you, because you introduced it on Thursday, August the 10th at Buxton, where you made the presentation. And in many regards, it formed the basis of your larger presentation. How did you get to Article 15 and realize that it was such an important part of the Constitution that has relevance to what a lot of the conversations we've been having in recent times?
Well, thank you, Dr. Hughes. In relation to my presentation, I had in fact not paid a lot of attention to Article 15 because, in my opinion, and Nigel I'm sure would agree with me, it forms part of a larger part of the Constitution in which it is described by Article 38, I believe it is, to be non-enforceable and non-justiciable. But particularly, I focused on Article 149D of the Constitution. And I believe it is a sort of a companion provision to Article 15, because it came out of the same constitutional reform process, and I believe Brother Eusi would have made a contribution to by the wording of Article 15. And I believe the Constitutional Reform Commission wanted to go further than just simply putting it in the Constitution as a principle of something to be attained, and decided that they needed to amend the substantive and enforceable parts of the Constitution to give effect really to what Article 15 importantly seeks to provide as the philosophical and political purpose, one of the purposes of the state. And Article 149D of the Constitution says that, that the state shall, for the purpose of promoting equality, take legislative and other measures designed to protect disadvantaged persons and persons with disabilities. So I believe that this provision, in my view, laid the basis for the constitutionality of what we refer to as affirmative action. And it was being built on the very provisions of Article 15 of the Constitution. Because Article 15, if I could start off by reading it so the audience...
Yes, please do.
What we're speaking about. It follows Article 14, and the marginal note, the side note reads, the further goal of economic development, after setting out what are the goals of economic development. But Dr. Hughes, permit me for context to read also Article 14, so that the readers would know how they flow. Article 14 says that the goal of economic development includes the objective of creating, promoting, and encouraging an economic system capable of achieving and maintaining sustainable competitive advantage in the context of a global competitive environment by fostering entrepreneurship, individual and group initiative and creativity, and strategic alliances with domestic and global partners in the private sector. And then it goes on to 15, which is says now is the further goal of the economic development of the country. The goal of economic development includes the objective of laying the material basis for the greatest possible satisfaction of the people's growing material, cultural, and intellectual requirements, as well as the dynamically stable development of their personality, creativity, entrepreneurial skills, and cooperative relations in a plural society. And this is the important part. The state shall intervene to mitigate any deleterious effects of competition on individuals or groups of individuals. So I believe that when taken together, Article 149 and Article 50, they lay the basis for the state of Guyana to provide them with the constitutional authority to ensure that there's a level playing field, to reduce discrimination and to reduce the sort of inequalities that permeate the society. And at this time, I really want to thank Nigel for the work that he would have done in exposing the sort of economic inequality that exists in relation to the allocation of resources and contracts across the length and breadth of the country. You would have heard Barra Jagdeo many times trying to justify it by simply saying, this is what the society is. But historically, it is a result of historical injustices and current policies that are being implemented by the government to ensure that as we look at the society, is one significant section of the population, whether we like it or not, we must confront it as a reality of our existence in this country. One particular section or ethnic group of the country receives considerably a greater proportion of the contracts. So it is not that the PPP and the government is simply, and the state of Guyana is simply to be left in a hapless and hopeless position, incapable of rendering it. But the Constitution mandates that they employ programs and policies to ensure that that does not exist, and that those persons who are disadvantaged, who are suffering as a result of competition and cannot compete, are placed in a position where they are empowered to participate in the economic development of themselves, their society at large, and the country, of course, as a whole.
Thank you, Roysdale, for that introduction there and to making the connection between Article 15 and the other section of the Constitution. Nigel, your introductory remarks, and then we'll get Brother Eusi in to give us some historical context.
Thank you, David. I want to endorse everything that Roysdale has said in relation to both Article 15 and Article 149 D2. It's not just the current policies, but the policies that have been in place for close to 2 decades. I believe when I was on your program last week, I invited your attention to the fact that in the press conference held by Barra Jagdeo, not this week, last week, he confirmed that all the oil blocks that had been given to persons other than international companies were given to Indian people. Now, if you think of the position of oil, and this is just one part of what has happened, the position of oil for the future of Guyana, and the fact that blocks were given to only one ethnic group on the admission of not only Barra Jagdeo, it was during his period and also during President Ramatar. It means that you have a direct transfer from the state to one ethnic group of an advantage of no mean order. Because once you have an oil block, you can then go in the international market, you could put it in the stock market, you can find by private treaty persons who are going to be able to engage with you in the exploitation of that block, and you make real money. You make millions of US dollars by virtue of just having that asset transferred to you from the state. If you go back from 1992 and we were to disaggregate the assets that were transferred from the state, I'm not even going beyond that, from the state to one ethnic group, you will see that more than 75% of those assets were transferred to one ethnic group. So what that does is not only the benefit of an immediate transfer, it also creates the economic basis for their growth, for the growth of the next generation, and it prevents anybody else who has not had a similar benefit or advantage from not only being disadvantaged, but they are almost locked out of any future participation in that activity. And the blocks are a great example. Mr. Jagdir went on to say that yes, we agree that we only pass it to one ethnic group. But he says, well, now we'll put it in the open market and we'll get bonuses. Now, if you have already passed 3-4 oil blocks to one ethnic group, and then you say, let's put it on the open market, how is anybody who is not the beneficiary of that oil block going to begin to even be in a position to bid against anybody else in the open market because they've been disadvantaged? So it's like if the state gives to Roysdale 15 million US dollars in an asset, Roysdale takes that asset, uses it to his benefit, and it generates, let's say, 40-50 million US dollars. And then we say, okay, open market, now let's bid for the same asset or a similar asset. I, who never got the 15 million, I, who certainly did not have an opportunity to take the 15 million and make it into 50 or even make it into 20, cannot now be said to have an equal opportunity to bid in the open market when you have disadvantaged me, not only by putting Roysdale in an advantaged position, but you've tied my feet. Where am I going to get the money to begin to compete? And so Roysdale then takes that 50 million. He will acquire more assets, and therefore the distance, a gap between me with no asset and Roysdale with the state asset and the benefit that he, or the use to which he's put it, is even more disadvantaged. And that is precisely why Article 15, one of the reasons I suspect why Article 15 was brought into effect was because they realized that competition, if you want to call it competition in those circumstances, can have some very deleterious effects. And if you don't intervene as the state, nobody else can intervene to amend that. If you don't intervene as the state to protect those citizens that you, the state, have disadvantaged, and not even if the state had disadvantaged, but even if there's a section of the population that has been disadvantaged for whatever reason, historical or otherwise, the state has a responsibility to come in and protect them and reduce the deleterious effects of that competition on the state. And this goes back to the political origins of Guyana, because both of the major parties in Guyana had an approach to the state that was born out of a socialist philosophy. I know that may be a bad term, but they certainly believed that the power that the state had should be used to ensure that in as far as is possible, you have some level of equality in the real sense, and that the state would not allow any sector of the population to be considerably disadvantaged. And so the state had the power by virtue of the Constitution. As a matter of fact, it's not just the power. Article 15 mandates the state because it says the state shall intervene. It's not the state may intervene. The state shall intervene. It's mandatory to deal with these matters.
Thank you very much, Nigel. Brother Eusi, are you hearing us?
Yes, I'm sort of hearing, not very clearly, but thank you very much. Are you hearing me?
Yes, I'm hearing you. When you heard Brother Nigel at the Coffee 250 forum, and then we spoke, you then said that you had something to do with Article 15 in the Constitution. Please walk us through the origins and history of how that article got into the Constitution.
I said Article 17, that's what I thought I had heard. But it's the same article. And if I said I had something to do with it, that is very true. But what I should have implied or conveyed was that it came from the Working People's Alliance, in which I was very active at those levels and other levels, including sweeping the office. May I touch on another aspect of this whole complex of inequality and why the WP had to make that kind of recommendation? It came at a time when there was a constitutional reform commission of some kind that included the political parties and civic society. At that time, Dr. Rupert Ryan was our representative in Parliament. I had resigned after the extension of the term of office so that other people can have experience of Parliament. Now, during the setting of that commission, which was a kind of parliamentary commission, I think it was chaired perhaps by Mr. Ralph Ramkaran. I won't be too dogmatic on that, but I think so. And I think Mr. Miles Fitzpatrick was also part of it, but it included civic society, and that is why certain things got in. Now, the two major parties, if I may say so, were very much together on certain of the executive powers in the Constitution, which it was very hard to modify in their presence. And I think they had a decisive majority. When Brother Rupert Ryan reported, and we saw what was going on, I think I was the one who made the argument that fair and free elections had taken place, and that was a good foundation for the society and the state, but that it would not solve the difficulties faced by multiple sectors of the population here and there. So the draft we put forward was that if any demographic in the society defined by race, religion, age, or region should complain to the government or represent to the government that it was falling behind the general rate of progress, the government shall be bound, I don't remember the exact words, and I can't read these days, I can't find it, but the government shall be obliged to negotiate with that sector, and together they should work out remedies for the state or affairs against which that sector is complaining. We saw that as being very fair because it did not speak only of one ethnic group or one democratic one age group. It was very as defined as it could be. Then Brother Ryan took it to the commission. They shut it down and came back empty-handed. And here I can speak for myself. I argued that if a provision like that could not get into the revised constitution, we are wasting time. We had fair and free elections, and that was a healthy foundation for the society. But it did not satisfy everyone. In fact, some people were against it because they knew how the state operates. The struggle has been as someone hinted before me just now, for the control of these executive powers of the state, rather than for the satisfying of the needs of the people. Now, when we sent that back with the second time, the comments I just mentioned, and it came out in about 3 lines, but it included, the state shall intervene. We did not see that until it was printed, maybe in the bill to be passed in Parliament or not. Good.
Thank you. Thank you, Brad.
I'm not finished.
Oh, you're not finished? Okay, go ahead.
There's something else I did not hear, and I want to put in possession of people who are active there today.
Hello, brother Eusi?
Yes, I'm going on to say that this chapter 2 is a peculiar chapter. I heard what the first attorney at law witness before, and I'm very informed and enlightened by the discussion of the 2 lawyers. I'm glad to be in their company, and I apologize that I have to be in there to perhaps take to make the discussion less professional, but the whole thing was that.
You're talking about chapter 2.
About the pardon?
Chapter 2?
Chapter 2. I'm talking about chapter 2. All of this about. In 1978, the government had denied increments to across the board to government employees. The circular, by circular. Instead of having annual negotiations for wages and salaries, they had issued a circular denying them, whether it was in the public service, in the sugar industry, in any government employment, 1978. The person who took that matter to court was a worker named Mr. Teemal, Deemal, belonging to NASI, which, as you know, had as its chairman attorney at law Mr. Ashton Chief. This circular was contested in the High Court. It was lost. The pleas of the workers were lost in the High Court, and it went right up to the Court of Appeal. If I am boring the audience, please let me know.
No, you're not boring the audience, brother Eusi.
Right up. It went right up to the Court of Appeal, where the workers won. And the workers won because the judges of the High Court read the Constitution. There were 3 of them. I remember 2 of them. One of the locals, I think Mr. Ronald Locu, or one of them, he was on the Court of Appeal. Mr. Keith Messiah, Chancellor. And I think the 3rd, and I apologize to his spirit, if it was not he, I think the 3rd was someone like Mr. Dan Japan, who was more of the official mind. But anyway, I'm sure that 2 judges, if not the entire court, struck the circular down. I remember Mr. Messiah's reading Article 11 of Chapter 2. Article 11 says words to the effect that trade unions, cooperatives, and other organizations of a national character are entitled to consultation in matters concerning their interests. And Mr. Messiah said, we have to give this Constitution some teeth. and in that mood joined either with the other judge or with the rest of the court in striking the circular down. And they struck the circular down. They struck the circular down. The circular which had denied wages to the entire body of government workers. Well, it did not end there. The government responded by the Labor Amendment Act 1984. It was moved in Parliament by the Honorable Mr. Shahabuddin, the distinguished Attorney General, and that Labor Amendment Act, which I hope the experts on this panel will research and correct me where I am wrong and put the record straight, because I'm talking from sheer memory and could not even look up anything. I have some, because of my vision. Anyway, when the opposition said, in Parliament said, you are interfering in the court, Mr. Shahabuddin said, no, we are not interfering in the courts. We are putting a decision of the Court of Appeal out of action. Those are his words. We are putting a decision of the Court of Appeal out of action. Good. I learned later, I'm about 3/4 finished, because it is unnecessary for me to say some things that have already been said. But I want to say that Chapter 2, if you look at the last article, that was added sometime after the Constitution came into effect on the appointed date in October 1980. I want to point out that there was the last article, which I was able to ascertain about a year ago. The last article says that Chapter 2 is not enforceable. Now, Chapter 2 contains all those, I did not know of Article 149 and can't locate it right now on what else it deals with. I was very glad to hear that I think it's Mr. Ford read it. Article 2 is not enforceable. When the Constitution first came in, I think they said it was borrowed, the style was borrowed from India. But it's there, declaring a lot of high-sounding principles which can encourage and motivate, especially working people and people in the society who feel deprived. They move a special article, a special amendment, and I cannot give the date of that, but it may be in the marginal note, or it can be found. The law will know how to find it. The last provision in fact, Chapter 2 says, this chapter is not enforceable by the courts unless Parliament had previously said that this or that article was available for adjudication. So it is a lot of pompous phrases, high-sounding, enlightening, and uplifting that you can't take to court according to the wisdom of those who drafted the Constitution. Other lawyers may have other views about it, and it will be nice to hear them. But, or in any case, I'm inviting them not for the first time. I expressed my disappointment to Brother David Hines because I said, I had made a public recommendation. Of course, the public has nothing to do with all of this. They just listen. I made a public recommendation that it will be wise to have a campaign to make Chapter 2 justiciable. And I should like those of you who are on the panel and have your references here to let the public know at once. If you look at the last article, to see whether my recollection is correct, because I'm very near to it and at my age, and I may be dreaming or something, but so far as I'm aware, this is very sound citation I'm giving. Finally, the last thing I want to say is that I learned a few hours ago, much to my astonishment, because I follow these things up in my activity. Part of my activism as a political activist was to read the official gazette and read the legal supplement and study those bills before they came to the floor of the House, whether I was in the House or not. So I should like it to be ascertained whether or not Chapter 2 is justiciable. The final thing I learned not many hours ago is that Article 11, which the judges of the Court of Appeal employed to strike down a very unfair circular to working people throughout the economy, or government working people, I should say. Article 2 was repealed in the year 2003 by a bill brought to the National Assembly. Thank you.
Brother, you see, before you go, I know you give us quite a bit there, and I will have Roysdale and Nigel respond. But you are a political activist, not a lawyer by certification. You are not a lawyer by certification, but obviously, from your account in the last few minutes, you took a very active interest in the Constitution. Why do you think it's important for political activists to take an active interest in the Constitution and the laws of the country?
You're asking why?
Yes.
I would say for obvious reasons.
But I know, but I want you to say those obvious reasons.
That is the ultimate horse on our back. That has all the powers of amelioration and repression and everything. We have to know it as far as possible.
Thank you very much for that. And yes, go ahead.
Hello?
Yes, go ahead.
No, that's all I'm saying. You have to know it.
Yes.
Because it is a supreme law. We have a system of judicial review. All government officials are subject to it and can be brought to book if we make the time and get the popular support for such action. And that is how I see the Constitution in part.
Thank you very much, Brother Eusi. Thank you very much.
I repeat, please study the official gazette because they drop things on you overnight. I never knew. I'm such a bug. I'm so addicted to studying this thing. And only a few hours ago, I knew that Article 11 had been repealed in 2003 under the watch, I think, of the present majority party. I don't know all the details of it because having seen the Court of Appeal use it to rescue a demographic in need of support or in need of social justice, I still cannot think how cold-blooded it was to go and strike down that very Article 11, which had come to the rescue of people hurt by authoritarianism of an extreme kind. Yes, that's what I want. I hope that answers your question.
Yes, brother Eusi. Roysdale and Nigel. I grew up, of course, as you all know, in the WPA and before that in Buxton with brother Eusi. And we know that he was always in conversation with the lawyers. You know, he was always talking to Peter Britton and Benji Gibson and all of them. So this is not new with him engaging here. You all have heard him.
That's right. That's quite right.
Yes.
That's quite right. I took my concerns to especially Benji Gibson, my Fitzpatrick, who are constitutional lawyers, and to Peter Britton and criminal cases and so on. Yeah.
Yes. Roysdale,
although I have that, I always knew I'm not a lawyer, and I need verification from qualified people.
Roysdale, you and Nigel are now the Peter Brittons and Benji Gibson and others. Your response to Brother Eusi, and then we go to Nigel.
I believe the population should have listened carefully to what Brother Eusi said. It came from not just an academic understanding, but integrally involved in the affairs of the country at that time. And he's absolutely correct in his memory, even though he's saying he's approaching dotage. But I don't think so at all. He was quite accurate in his recollections. The case that he referred to, the Timal case, is one of the significant constitutional law cases, a landmark case in Guyana and the Caribbean. And I believe that it was after that case, as Brother Eusi said, the Labor Relations Act would have been passed to correct, from the government's perspective, the decision to put it into desuetude and to nullify the decision of the Court of Appeal in relation to its interpretation and the impact it would have had on the workers' rights in 1984 at that time. But he's also accurately correct in that Article 39 now provides, Article 39(1) now provides that these are simply to be guiding principles by any public agency, and unless they are made specifically enforceable by Parliament, only then could it be enforced, which we would refer to as being justiciable. So that is why, if you recall, Dr. Hines, at the commencement of my opening, I pointed out that the provisions of Article 15 fall in part of a constitution, which are not really enforceable in the court. And that's why I tried to look to see where else we could have found a similar but enforceable type of provision, which would capture some of the elements that would have been set out in that part of the Constitution. And I believe we have some basis in Articles 149 D2. But importantly also, as Brother Eusi pointed out, Article 11 has been completely repealed in the same constitutional reform process, which gave rise to a number of these provisions that we are speaking about. I believe that in the armory of the citizens, these provisions are very important provisions. I believe that at the time, the argument was that there was a great gap between the capacity of the country at the time to match many and fulfill many of these principles, and they were too lofty and incapable of realization. For example, they said that at that time, Guyana was too poor to provide universal education. At that time, Guyana was too poor to provide universal health care. And I believe that argument at the time seemed to have taken sway, and the majority voted to repeal those provisions. I believe that, however, a number of important things were also thrown out at the same time in terms of the economic system, the right for free and fair education, the right for the citizens to participate in the affairs of their country. All of those provisions were lumped and not carefully dissected, and they were all caught together and simply made non-justiciable. I believe, and I support the call for us to start a movement to have these provisions reinstated as justiciable provisions, because the rationale that existed for them to become non-justiciable certainly don't exist now. We are the fastest growing economy in the world. We have billions of dollars in reserve of oil, and Guyana now has the economic resources to fulfill the destiny of the original constitutional makers, who felt that we must put in place the sort of provisions which will urge the state to move towards an egalitarian society. We don't use that term anymore, but that was the underpinning of these provisions, to ensure that every single person would be provided with an equal opportunity of moving beyond their circumstances. And the disturbing thing that we face is that even though Article 39 now says that we are simply to be guided in the implementation of policy and programs by these provisions, this government simply does not possess that mindset to which the Constitution requires the state and its government to operate from. And one of the areas in which we should be turning our attention to assess whether the government is acting in accordance with the principles, because they're only principles now, and to give effect to Article 149 2D in terms of affirmative action programs, is to look at the budget and to see what is the impact the budget is having on the lives of the ordinary people of the country. We continue to spend considerable sums of money, in many instances proportionately more than CARICOM states, for example. But in terms of impact and quality of life, both education and health, you would see that there's no major impact taking place in the lives of the ordinary people. The research that Nigel would have done indicates at least 42% of the total budget is spent on infrastructure. And when you continue and build on the analysis that Nigel would have done, when you check to see where that 42% ends up, it ends up in the hands of one ethnic group. So in terms of the overall analysis of what is actually taking place in terms of the government giving effect to these principles, they're not. And I just want to add, a very important statement, which I refer to in the Buxton presentation that I did, which was from a case, a South African case. And this is the crisis that Guyana finds itself in now. Because I want to go back to what Nigel said. It's a very important example of the oil blocks. You've now given out all the oil blocks to one ethnic group, and then you decide, listen, let us have an open system, a very fair system, to allow everybody to bid in those circumstances. And in looking at that backdrop, I want to refer to what Justice O'Regan said in the South African case of the President of the Republic of South Africa against Hughes. And this is what she said at paragraph 112. Although the long-term goal of our constitutional order is equal treatment, insisting upon equal treatment in established inequality may result in the entrenchment of that inequality. And that is exactly what is happening in Guyana. We started off from a position of extreme inequality. The state sought to intervene by acquiring assets to engage in a process of some sort of equity. We had the divestment process, and then we had the PPP entering government and accelerating the transfer of state resources to one ethnic group. Having established an overwhelming advantage in many instances, they now seek in certain examples to say, listen, this is an open open economy. Let everybody bids for contracts. But that is the problem that the Constitution intends to deal with. And we have a government that seems very determined not to give effect to the constitutional principles, nor even to import into the policy and the budget a fair and equitable distribution of the resources.
Thank you very much, Roysdale. Nigel, I know you've been boxing the books there.
No, I was
Your
just
response?
no. Eusi's recollection is immaculate, absolutely immaculate. And I do want to say it's always a privilege for me personally to share any panel, share space, even if it's not on a panel with Eusi, and of course to express on my behalf, and I may be bold enough to say, those who stand on his shoulders, our gratitude for all that he has done. In my early days as a young lawyer, he had come to me, and I know that we won some case before Justice Prasad, and it had to do with the electoral system. But be that as it may, I endorse everything that Roysdale has said. And I agree with the call by Brother Eusi that we should form a campaign to make this justiciable. What I do want to say is the subcommittee that was set up to advise on constitutional reform under the APA and UAFC government in 2016, which I coordinated, one of the recommendations made by that committee was that all of these provisions become enforceable as rights. So effectively justiciable. That was certainly one of the recommendations that we made. But we're not a country that spends time going back to see, what can be done. The problem that we really face now is that certainly I know two ethnic groups have their backs against the wall, the indigenous and the African people. And I don't think that is an exaggeration. I have done minuscule research, but if you really look at all of the numbers, you pick your sector of economic endeavor in Guyana, whether it's banking, insurance, retail trade, you pick it, construction, wherever, and there is no sector of this economy in which there's anything close to parity. Shipping, the waterfront, pick it. You just pick it. Now, if you have a country that you're purporting to run in which there's that level of disparity, just think about it, the financial institutions, the insurance industry, all those industries, I don't need to go through them. And you have that level of inequality disclosed by the figures. One of the reasons I'm calling for disaggregated figures is that we must bring them forward and discuss them. Roysdale has said this, the unpleasant truths. We have to deal with them. And once we discuss them, we have to find policies to reverse that impact. And saying the open market is the basis is not reversing that impact. And I believe that we are at the stage now where we have to have serious discussions on it, because it is almost as bad if you had laws that effectively prohibited certain sectors of the community from participating in the economic benefit. That's the impact of it. You don't actually have the laws, but the reality is, if you put out contracts now for bid, and depending on the criteria you identify, you have virtually shut out anybody else except one particular ethnic group from participating. So to take the extreme example, in indigenous communities, none of the infrastructure work that is done by the indigenous. The people who win contracts to build build roads to indigenous communities, the people who win contracts to build schools, to build hospitals, are not indigenous in their communities. And similarly, if you take the figures and the numbers and you come closer to the coast or come to the coast, it is almost exactly the same in the African communities. And that's before we even get to any other discussion. So the question is, I agree, Brother Eusi, we need a campaign, but I think we need something stronger than a campaign. Because, we love to say the horse is starving and the grass is growing. And if we're desperate today, if the backs of the African peoples are against the wall now, where are they going to be tomorrow?
Nigel Hughes there. Nigel, Eusi, and Roysdale. Roysdale, you wanted to say something?
Yes, and I agree with what Nigel is saying. But when I look at the Constitution, sometimes I wonder um, if it is allowed to function, whether we would be in some of the problems that we find ourselves in. And, in preparing for the same Buxton presentation, Nigel, I discovered the provision, Article 212N of the Constitution, which deals with the establishment of the Human Rights Commission.
Absolutely.
And interestingly, this is the only constitutional commission which has never ever been established. And I delved in further to figure out why this. And one of the reasons why is because this commission is mandated to do much of the work in a sort of objective way, to provide us with the information that is necessary to point the government out, to say, listen, you are falling short of your overall constitutional obligation to ensure an equitable and fair society. Article 212N requires, so that the purpose of this commission is that it must promote the observance of and respect for and protect and investigate violations of rights recognized by this Constitution and any other law related to equality of opportunity and treatment. Then it says in E, it must carry out or cause to be carried out research and studies concerning the observance of the rights and make reports of the findings and recommendations to the National Assembly. It must investigate or initiate investigations, and it must take appropriate action on behalf of the persons whose rights have been likely to be contravened or violated. So the sort of purpose that this Constitution Commission serves is to examine almost on a sectoral basis, as Nigel was pointing out, what is happening in terms of equality of opportunity. We have an economic system in which there's no, in terms of a formal banking institution, none is owned or controlled by an African Guyanese or an Amerindian. I've gone to court representing a number of African Guyanese, trying to ensure that their rights are protected so that they could become registered as auditors and chartered accountants in this great republic of ours. We have a system which is almost a syndicate, which seeks to exclude them from becoming registered. Whilst at the same time, Dr. Hines, and we see when you speak about these things, you're accused of being racist. But this is not about being accused of racism. These are facts. When the bank now require that you are in a position to produce a chartered audited financial statement before you get a loan, you see the sort of dynamics that are taking place in the society. When you look at the lands, and I did a little walkabout in Buxton a few days ago, and myself and some other colleagues, and you see the extensive acreage of Buxton and the depth of Buxton, and the fact that there are no proper roads existing in the village as a whole, much less to the farming communities. But you see the government spending in the budget billions of dollars in certain communities only to say that they are providing factory to market roads and factory to market roads in these communities. These things encourage a certain degree of dependence and further impoverishment, because they are not able to provide and compete. And this is part of the structural discrimination that is taking place as a result of the government's policies and as because of the historical injustices that would have taken place. So imagine now, Dr. Hines, vast villages, predominantly African Guyanese villages, are no longer in a position to feed themselves effectively. They now have to go and purchase food. They purchase food from other people who produce food. They purchase food from people who are provided with the resources to engage in meaningful agricultural production. And you would see that in the very Constitution, well, one of the things that, you know, in the same article, Article 40, is to provide a competitive advantage to everybody in the country. So when you fail to provide people with the resources and to build out in their communities the infrastructure that is necessary to move them so that we could achieve what is provided for in Article 15, the growing material, cultural, and intellectual requirements, we have what is taking place and is likely to continue to take place in this society, which is a continuous situation of marginalization. And it's going to pass on with the government's policies, if it's not checked by the other sectors of the population, other members of the population. This is going to pass on almost from generation to generation, and you're not going to participate meaningfully in the wealth of your country. You're going to lag behind to such an extent, as Nigel pointed out, and I agree completely, that it becomes impossible for you to even consider yourself a competitor.
Thank you, there, Roysdale. Nigel and Brother Eusi, I can't have both of you on the panel and not touch on this issue. In 2023, at the very Coffee 250 presentation, Nigel Hughes called for a supermajority in Parliament as one of the means of dealing with the ethnic competition in the country. Eusi Kwayana, then Sidney King, in 1961, I would submit, address this very subject. 62 years later, Nigel Hughes is addressing it. Brother Eusi, in 1961, as you engaged this subject, before we became independent, before power sharing was being taught and studied in universities, what is it that drove you and the members of the African Society for Racial Equality to engage this issue of shared governance and power sharing?
That's a question?
Yes, Brother Eusi.
I didn't get the question.
No, I'm asking you the proposal for joint premiership in 1961. What drove you and the members of ASRE to engage that subject?
I would say knowledge of the society. I lived in the midst of the masses. I was born on a sugar plantation, grew up in a village, and up and down. I went to primary school with a lot of people of all races, and I heard Dr. Jagan speak. Before I heard Dr. Jagan speak, I was an associate member of the Indian National Congress, fighting for Indian independence in Guyana. And I don't regret it. And my friends go back to there. And so I was never in a sort of position above ground or in the sky. I knew what society was. And I knew feelings of people. I listened to people. The feelings and fears and suspicion and hopes as well. I remember those campaigns fought by Dr. Jagan. I went to him as a public school teacher every Friday afternoon. He would pick me up at the public road out of school, and I would go to the quarantine and or east or west coast, Demerara, and grounded people. And I think that's on and understanding the country, understanding the people. I also slept in many indigenous homes in the interior the Aruka River, and I don't know. I was lucky, that's all I can say.
Power sharing, they joint premiership?
Yes, well, I mean, that was not, it was not an academic thing. It was a response to what I saw as the needs of the society, of the working people. It was not creating a theory, it was a response. You know, you look at something, you look at the way things are moving, and you say, well, if so and so is not done, it will go in a different direction. Let me be more precise. We have in particular masses of human beings who have gone through particular forms of bondage, including the indigenous people. Among all those people, you had to find and understand there was an aspiration for full human dignity. It's one country, and if they are to be in one government, what is wrong with sharing the aspiration? All of them were very valid aspirations. I didn't think any one of them was wicked to want to, be represented at the top of society. And if we all have the same desire for a certain social goal, and the goal is indivisible, why not share it? If you remember in 1984 when the GUC held a conference and invited the PNC, the PPP, and the WPA to respond to a proposition, they put it like this: Socialist Guyana, the way forward and upward. The WPA sent me to represent our views, and the paper I put forward is still available, Towards a Democratic Republic. And it had that same sharing in a different way. I did talk about joint premiership then, because we were already a republic. I talked about a democratic republic with a head of state that's rotated, because that is what the masses of people want to see. They don't want to dominate anybody. They want to see themselves represented at the highest level and not ignored. And these are some of the, common sense ways of achieving that. And one thing I want to say to the public in general, whenever I make a recommendation, I am not bothered if people tear it up, provided they look at it and do something better. But I feel if we just remain static, I heard a lot of recommendations tonight that are very laudable, and I hope they will go forward. But we must do something, not I don't mind criticism and people saying that and twisting what you say. And the point is, if there's recommendation, anything I recommend can be improved. That's my position. And I will support the improvement. Those who work with me know that. I don't hang on to what comes out of my head.
Right.
So I don't know if that is what you were trying to.
Yes. Before I bring in Nigel and Roysdale on this issue, you've been, brother Eusi, you've been telling me in recent times about this view that people have that when you talk about power sharing, that you want to share their power. And yes, talk a little bit about that.
You know, let me explain something I never explained before, please.
Yes.
You remember when the election was held and the Jan-Jack began to be reported in the press, and people began to criticize a particular functionary, and they wanted me to speak. I don't know why.
You mean the 2020 election?
A younger generation of Guyanese presented Moses Bagwan and me, I think, with a draft and asked us to sign it because they were afraid that the situation would degenerate. When I looked at it, it had power sharing in it. They didn't use the word power sharing. It was a recommendation that somebody should resign or let the opposition take that place. I would not have written that. For the same reason, because people come to think they are entitled to power. And when you talk about power sharing, you don't want to share it, you want to steal what belongs to them. I don't get into that kind of mess at all. I'm not interested. So what I did was to add a paragraph which nobody has read, welcoming the observers and saying there is this agreement and it is lucky that the observers is here. The observers are here, they will be able to take an independent view of the electoral process. I inserted that into the draft that was given to us. I'm saying this for the first time. But in spite of that, I became the devil because I wouldn't open my mouth and curse somebody about doing some kind of forgery, you know. I just said that I don't do that. I attack at the top.
Nigel, 2023, supermajority. Kwayana talked about looking at the society, and he kept saying he was driven by what he thought the people want. Is that what is still driving this this discussion about democratic sharing of governance?
David, I think it's a sad commentary on us as a people that if Eusi said this in 61, you said? 61. 51 or 61?
61.
61.
Yes.
And if we were keeping track of our history, it shouldn't be fresh today. I don't think I've said anything that should not be, but we continue to forget our history. And I suppose in the words of Jim Jones, we're condemned to repeat it because we're getting excited again. No, not excited. We're discussing whether it's consensus, whatever, when all the indicators since the 60s, when the split, the split was there before, all the 60s did was that it became more manifest. The division in this population has always been there. Let us not fool ourselves that there's some halcyon day back in our history where everything was honky-dory. It never was. And so that has constantly been the cry of all our people, that we all want to be represented in government. And so saying it in 2023 is merely a repetition of what has happened. What it is, however, is a sad commentary in the fact that we have gone nowhere. After whatever was that, 70 years, we have not progressed in this discussion on how we will manage our national affairs collectively. We are exactly at the same place. We are pre-Civil War, as we were in the early 60s, and we have exactly almost identical problems today, which is really a commentary in the fact that we have no mechanism for dealing with our issue. There's one point I want to raise, though, on this democracy. If, David, you are an extreme right-wing person who campaigns on, let's say, policies which require, which by inference and explicitly mean that some sector of the community that doesn't look like you will not benefit if you were to get into government. You get into government, quote unquote, democratically. The segment of the population who are at the receiving end of what have been your rhetoric, now with the power you put into effect by policy, are they supposed to sit down and wait 5 more years for the democratic process to remove you while you wreak havoc carrying out what was rhetoric before? And what I'm really asking is, what are the mechanisms available to those persons who are the victim of your severe policies which target you? What are the mechanisms? They're supposed to run around without resources and gather data and go to court and ask for a declaration and then hope that somehow or the other it will go further. Provisions that are not justiciable, which means you can't go to court. So what do you do in those circumstances? What is the standard operating procedure when somebody's got a gun to your head?
Roysdale?
Dr. Hughes, we're back at the original question of Guyana. How do we live together in a fair and democratic system? I believe that whilst the concept of a supermajority is important and it will play an important role in mediating the problems that we have, I favor additional mechanisms being brought together with that sort of approach. And what I'm thinking about, I believe that it is time for us to engage in the meaningful devolution of power. And I believe the Constitution of Kenya provides us with a fair example as to how we could go about it. In Kenya, there are 47 counties. Each county is an independent, self-governing authority. They're in charge of most of the activities that the average citizen life would be impacted on: education, health, environment, sanitation, schooling, and those sort of resources. They are provided with a specified proportion of the government's subvention. It is fixed in the Constitution. They could raise their own taxes, and at the same time, there's a county development fund to ensure that each of the 47 counties move to some sort of parity and equality in terms of quality of life. You see, Dr. Hughes, being a 3-year-old member of the National Assembly, I fear that even at the point of the supermajority, for example, in relation to a budget, Nigel, we would strike the deals. It will force consensus. But the problem that we will find is the implementation, execution of the budget. So, for example, we say that we need 60% to pass the budget. The government will come, sit down and say, we want X in, we want Y in. The people in the Rupununi need better roads, hospitals, and you put the funding in the budget, so it passed with 60%. And after, we go back to the same system that plagues the country, which is in terms of the execution and the access to the resources. So what takes place after? Who gets the contract? We end up with a situation continuing and perpetuating itself. So I favor a system where, yes, we start with the supermajority to force consensus so you could actually get what you want at a national level. And then at the regional level, the funds are beyond, in many instances, beyond a supermajority. They're built into the Constitution, and the local entities are provided with the legal right and the constitutional power to actually provide the sort of quality of life that we need. I favor that coupled with a very firm and important system of devolution.
Roysdale, I just wanted to come back. One of the things I didn't say that supermajorities were the end. I did in that presentation say you needed disaggregated data to disclose what was happening at the policy level so that you could then take into account whether parliamentary or lower, policies that will rectify what the disaggregated data shows us. And I agree completely with you, the execution. But if you have that disaggregated data that shows which sectors of the community clearly are disadvantaged, at least you begin at the National Assembly, apart from the allocation of funds, to approve policies that can be implemented to rectify it. So we're not necessarily at cross purposes, but I accept the reality of politics in Guyana.
Yes.
And I just wanted, just Dr. Hines, just give me
Brother Eusi, you wanted to say something?
Yes, I just want to clarify something, please.
Oh, go right ahead.
I heard it may have been suggested that I am against power sharing. I'm not against power sharing.
no.
I'm against calling for power sharing because I'm being seen as a thief of power.
Yes, we got that. We got that, Brother Eusi.
Secondly, I feel the way to. I want to remind those who know that my attitude to this thing is a little different. I moved in the National Assembly when I was there a motion for a national dialogue of all social forces. And it was passed unanimously. It is probably the only thing of that nature that was passed unanimously by all the parties in the National Assembly, however they got there. It was undermined, the dialogue never took place, it opened and forces in certain places undermined it. But that is how I will not want to discuss solutions that are not treated in that sort of way to be in the first place, put before bodies of people who can mold them and grow along with the discussion. So that is all I wanted to say. That is why I said nothing and made no particular recommendation.
Okay.
I've heard some very interesting recommendations. I want to warn about the implementation, the way of getting them accepted should be very public and open and popular, involving groups of people everywhere. And I don't know how, but it can be done.
Okay. Roysdale, you wanted to...
I just want to beg that that element be not
Right.
forgotten.
Okay. Roysdale?
Yes, Dr. Hines. I just wanted to build on the discussion that Nigel and I were having. One of the important areas that were never been given effect to in the Constitution is really and truly the due devolution of power to the Regional Democratic Council.
True.
If you check our Constitution, our laws, these bodies are just simply named, and the only purpose they serve is the electoral purpose. So they are not empowered to deliver resources to communities. For example, Dr. Hines, the local government minister could decide through the regional executive officers where the money is to be spent, how much it is to be spent on, which villages are to benefit. And I believe that that is one of the important problems that we have in society, is that we are suffocating the entire country. And we are forcing ourselves to a situation where we continue to battle over national power, and we continue to battle over the access to resources, which seems to be growing at an exponential rate having regard to the discovery of oil. But the ordinary citizen can't vote for someone in their own communities who's empowered to deliver for them. For Region 4, for example, Dr. Hines, Region 4, you have an REO who runs the council. The council is not in charge of determining anything, which schools must be built, which factory to market roads must be given privilege or access or priority to in terms of development of communities, health centers. They can't determine the school capacity or anything. And so you're having, they're just sitting there basically as a council. They can't determine how the money is to be spent. When you go down to Region 9, you see the same thing happening. A majority of Amerindian people and indigenous people live in Region 9. They vote for a regional democratic council. But the Regional Democratic Council have no independent authority to make any decisions. It all comes back to a very centralized and bureaucratic system.
Yes.
An abuse of power.
Abuse of power.
An abuse of power. That's all.
Yes. From top
down.
Yeah.
An abuse of power going on.
Yeah. Yeah. Nigel and Roysdale, I promise, because it's an issue that I have an interest in. The whole question of power and how it's shared, why it should be shared, etc. And it's an issue that we'll come back to. Brother Eusi, I will give you the last word because there are hundreds of people who are live on this program, and some of them are hearing your voice for the first time. As you would say, a 98-year-old man in his old age, as you would say, what would you like to say in closing to the hundreds of people who are on this live and who will view this program later on tonight and tomorrow and the coming days? But is it?
Who are you speaking to?
You.
Oh, I didn't get, I don't know. Please repeat.
No, I'm saying that I'm giving you the last word because there are hundreds of people who are on this live program and who will view the program later on tonight and in the coming days. And some of them are saying that they're hearing your voice for the first time. Others are glad to hear you, who know you. Your message to your message to the viewers. Yes.
Thank you very much for your kind words and and I hope that we can all work together wherever we are and respect one another and one another's opinions. It's two lawyers who are on this panel tonight are very, very creative and innovative and I think, are moving in a very positive direction where empowerment of the people and recognition of the people, the rank and file, ordinary people of Guyana who comprise the society are concerned. And that is where you should head. And I thank you very much for your patience and listening to all the nonsense I had to say. Thank you.
You're entitled to call it nonsense, but we know better. Nigel and Roysdale, your closing thoughts, and start with you, Nigel.
First of all, I want to thank you for allowing me to share some space with Elder Kwayana. We clearly have very serious problems about, almost every aspect of society. We were dealing here specifically with Article 15, and I think the general consensus here is that it lofty as it may be, it is of zero impact to the society. It's not justiciable. It's probably not even aspirational. But I think that continued discussions like this, and I want to repeat my commendations to you, to educate the public. What you are doing, David, if I can just say this very briefly, is addressing the political consciousness which has disappeared. In the old days, you had the Working People's Alliance, and you had people who were constantly speaking to the community about issues. They may not always agree with you, but the point is these issues were brought to the fore and they thought about them. And this is a useful process, necessary. You probably may not see immediate results, but I think programs like this, because of the issues they raise and the attempt to find solutions, are invaluable because it's not happening anywhere else. So I
Thank you.
just want to say, please continue.
Thank you, Nigel. Roysdale?
I agree, and I would like to join in the sentiments expressed by Nigel. I believe that your show, we have gone for an hour and 30 minutes. I think we have gone beyond the usual time, and I believe that in itself is recognition of the important issues that we would have been discussing tonight. I consider it indeed a privilege to be able to be and appear on a show with Mr. Eusi Kwayana, who I believe is indeed a legend and one of the great icons produced by this country. Dr. Hines, we started off discussing Article 15, and Nigel said we realized in the course of our discussion and presentations that Article 15 really is of little meaningful impact and substance. And we ended up discussing power sharing. And one of the important things that flowed from Nigel's comment in relation to the supermajority, which I support, is the interesting statement made by Anil Nandalal. And of course, I can't close without beating up Anil again. Nandalal proceeded to say that this was an effort to get into power by the back door. And it is a very sad and unfortunate statement to make. When we go to the elections, it is a manifestation of power of all the citizens of the country. And power sharing is not sharing the PPP's power, it's allowing another segment of the populations their manifestation of their aspirations and their dreams also to become realized. So they want to give effect to their power, to their representatives. And then recently we had it very much compounded by the president and the vice president, who proceeded to say that they don't have to speak to the representatives of the people. They have to go to the people themselves on the ground, which is an inversion of Articles 9, I believe, of the Constitution, which says that this is supposed to be a democratic state and the people act through their representatives. So we have serious and fundamental issues which need to be resolved in this country. I believe that the discovery of the oil, while it is a blessing, could well turn out to be a great curse to this country. Statistics show that most countries that discover oil without proper institutions being put in place descend rapidly into a state of civil war and social disconnect completely. So, Dr. Hines, I want to thank you for having me on this show. It was a very interesting and enlightening session, and I would like to return on any occasion to discuss these sort of important issues for our country.
Thank you very much, Roysdale. Thank you, Nigel, and thank you, Brother Eusi, for our discussion tonight. And I would like to thank you in the audience, as usual, for being here, but also for your contributions in the comment section and giving truth to what we are trying to do on programs like these, despite the fact that they say that we come here to make trouble. We are demonstrating every time we open the airwaves that we are more than people who are just interested in causing trouble. We are interested in moving our country in the right direction, and we feel that we have to have these kinds of conversation. And I'm glad to contribute to it. So thank you all so much. We're going to rebroadcast some of the programs on the weekend, and I'll see you guys again here on Monday evening. Love is always the watchword.